30 million from Diana, gone.
Bazillion-dollar case against the Daily Mail, lost on all 97 counts.
Potential embarrassment of the discovery process is nuclear. It really is.
This seems like they're in a lot of hot water, but also the judge, Justice Nicklin, is furious.
Prince Harry's court costs ruling lands this month, and the number dominating the headlines may not be the figure that matters most. You've heard £34 million. You've heard £50 million. Those figures are everywhere, but they don't decide what happens next. The key number is £16.2 million. Remember that number, £16.2 million, not £34 million.
He brought that bazillion-dollar case against the Daily Mail, lost on all 97 counts, and now it seems like he kind of knew his witness was horrific and bad news 4 years ago. Tom, what is going on?
Not £50 million. By the middle of this video, you'll see why it matters, and why his own legal team put a striking admission in writing to the High Court, one that became very important once the details came out. Here's what we're breaking down, and why the details matter. First, what Prince Harry could actually owe when the judge rules, including the exact amount being sought up front, a figure much of the coverage has barely mentioned. Second, the admission made by his own barrister in written submissions, which could seriously hurt his position and raise questions about how much protection he really has.
What do I expect to happen? I don't think the Mail will get the whole 34.5 million, but I don't think they'll be stuck with the approved costs either. I think it'll be somewhere in between.
And third, the second lawsuit behind this fight, with questions over who is funding it and what the real stakes might be. Multiple lawsuits, huge legal bills, and one very expensive legal battle. Let's start with the ruling, because that part is already settled.
Statement is being used by the Daily Mail. They are saying that the statement sort of shows the bad faith of two of the claimants, Harry and Doreen Lawrence, who put their name to that statement. It's interesting that the other 5 didn't put their name to it, isn't it?
97 claims were dismissed. On July 7, Justice Nicklin delivered a 436-page judgment involving the Duke of Sussex and 6 co-claimants, and the result was decisive. There was no partial win and no technical escape. The claims were dismissed. A total loss in the High Court can carry a major financial consequence, and that's something people outside Britain often underestimate. In the American system, people generally pay their own lawyers regardless of the result. In England, the losing side can be ordered to pay the winner's legal costs.
And that, of course, is what we saw with these very senior judges speaking out to the Times a couple of weeks ago, saying that Harry's statement had put Nicklin at risk, and that it was ironic that here's a man claiming that he's been put at risk and he is targeted, sort of inciting hatred, frankly, against this judge by suggesting that he was corrupt.
I mean, yet another hypocritical move by Harry.
That's why a case that began as a fight for vindication has now become a serious financial issue. The publisher's costs presented to the court were more than £34 million. The judge described that figure as unprecedented for a High Court media law case. Unprecedented, from someone who has seen countless cases like this. The honest read is somewhere in between, rather than the version designed for a dramatic headline. But somewhere in between offers little comfort, because before the final figure is assessed line by line, there's an interim payment, a sum handed over now, before the detailed assessment even begins. And here's the figure that's been largely overlooked. The publisher has asked for more than £9.9 million upfront as an interim payment, a global sum to be divided among the 7 claimants, with payment due on a date the judge is expected to set.
Actually, that doesn't affect how the costs go, because the costs are shared severally. So even if Harry's portion doesn't incur these kind of punitive costs, the fact that all the others do still means that they all have to figure out between them how to pay for it.
£9.9 million, before the rest of the costs have even been fully argued. The claimant's barrister called that demand excessive and unjustifiable. That's his position, while the judge will have the final say in a written ruling expected during the week of August 17. So, how much does Prince Harry actually owe? The straightforward answer is that nobody knows yet. It isn't £34 million, and it isn't £50 million.
Meghan and Harry going broke. They've protected themselves with a question mark, but the reporting inside is that things are very grim. Page 6, banner story on May 13th, per Sarah Nathan. Meg dusting off her suits. Money is tight, said a source in the know.
The final figure still has to be determined, and he should find out this month. That brings us to the safety net, the protection that was supposed to make the financial risk more manageable. The 7 claimants didn't enter an 11-week High Court trial without financial protection. They took out after the event insurance, a policy designed to cover the other side's legal costs if the case is lost. Between the 7 of them, their combined cover totals £16.2 million. £16.2 million. That's the number from the start of this video! This was supposed to be the safety net, the protection standing between Prince Harry and a potentially enormous legal bill after the verdict went against them. But then came a crucial sentence. In written submissions to the High Court, the claimant's own legal team conceded that if they were ordered to pay the publisher's costs on an indemnity basis, their current insurance cover would not be enough to meet their total costs exposure, possibly, they wrote, to the tune of many millions of pounds. Read that again. This isn't a newspaper columnist making the claim, or a commentator offering an opinion.
As another double-sourced told us that Markle and Harry need at least $6 million a year just for operating expenses in their home in Montecito.
It's an admission made in written submissions by Prince Harry's legal team, warning the court that the insurance may not cover the full costs if certain conditions apply. Put simply, the safety net may have a serious gap in it. The people relying on that protection have told the court themselves that the coverage could fall short. So what exactly is the indemnity basis, and why does that phrase matter so much? Under the standard basis for costs, the winning side can recover costs that are reasonable and proportionate, with doubts generally resolved in the paying party's favour. That can mean significant reductions when the bills are assessed. The indemnity basis works differently. It's a tougher approach to costs, generally used when a court considers that a party's conduct or litigation position warrants it.
Designers are not lending her clothes anymore, so she's paying retail value for that. Their security bill, they feel as if they need protection like the President of the United States. They have more protection than many, many celebrities. Hair and makeup, like hair and makeup. Like Meghan never leaves the house without a glam squad. That could cost $5,000, $10,000 a day.
Proportionality doesn't apply in the same way, and doubts can be resolved against the party paying the bill. That's why the distinction could become extremely important. £16.2 million in insurance cover is substantial protection against a standard costs order. But if indemnity costs were ordered against a bill exceeding £34 million, the potential gap could be enormous. And Harry's legal team has already warned the court that the existing cover may not be enough to meet the full exposure. That's the real issue here. It's not simply whether the headline figure is £34 million or £50 million. It's the potential gap between the insurance coverage and whatever amount the court ultimately orders, and the fact that the claimant's own legal team has acknowledged that risk. So the key question isn't just how large the bill becomes, it's whether the judge decides to apply the indemnity basis at all.
About who has earned more confidence. And right now, the momentum appears to be with William and Catherine. That's just what it is.
And Prince Harry's legal position in July could now make that decision even more significant. Isn't it? When the judgment came down, a statement described the outcome as a complete and obvious whitewash. Prince Harry's name was on it, along with Baroness Lawrence's. But the other 5 claimants did not sign. Sit with that for a moment. Elton John, David Furnish, Sadie Frost, Liz Hurley, and Simon Hughes all declined to put their names on the statement. 2 people signed it, and the publisher's lawyers have now pointed to that statement in their argument for costs above the standard basis. The issue they're raising is bad faith, while the potential consequence is an indemnity costs order. If the court agrees, the resulting bill could exceed the £16.2 million insurance cover. A statement attacking the judgment could now become part of the argument over who pays the costs. For years, Prince Harry has argued that his security situation is uniquely serious. Court applications, security claims, interviews, and his memoir have all focused heavily on that concern. Then, after the ruling, senior members of the British judiciary reportedly raised concerns that his statement had put a judge at risk. The security argument sits at the centre of the wider dispute. It's part of the reason for the Ravek litigation and the explanation given for why Harry believes his family faces particular risks when travelling.
Now, I'm going to make a wild guess that maybe one of these newspaper groups who want their revenge against Harry
Wow.
for the circus that he's been playing all these years, maybe they're backing St. Albans.
Yet after a ruling went against him, concerns were raised that his response could have created risks for someone else. That's a striking turn in the story, and it's based on comments attributed to senior judges rather than this channel's own characterization. Could Harry separate himself from the other claimants and argue that their actions shouldn't affect him? That's where things get more complicated. The 7 claimants are jointly involved in the costs position, meaning the financial consequences aren't simply divided into 7 neat individual bills. Severally is the key term here. It means the 7 can be responsible for the costs in a way that doesn't simply limit each person to an equal seventh. And it means the interim payment is treated as one global figure before the precise amounts owed by each claimant are worked out. It means that if the judge decides the conduct of the litigation justifies an indemnity costs order, Prince Harry can't simply say, "That was the others." There was apparently one claim in the case that may have had a stronger chance on its own, the allegation that someone was going to be placed on a flight beside Chelsea Davy.
But of course, if she's backed by a newspaper group, which is the hunch I have, looking for revenge, they're going to say, what do we care if at the end of the day we're down for 10 million costs? The number of newspapers we'll sell is going to dwarf that.
But it wasn't brought separately. It was part of 97 claims, and the overall case failed. Now the costs of that entire case are being assessed. So Harry isn't facing a simple one-person bill. He's one of 7 claimants involved in a case where every claim was dismissed. A disputed statement is being cited in the costs argument, and his own barrister has warned that the insurance may not cover the full exposure. That raises the obvious question: can he simply pay the difference? Then there's Montecito. Reports have put the annual operating costs at around $6 million before lifestyle spending, travel, or private flights. And against those expenses, questions remain about how much money is actually available. Harry also inherited substantial sums from his family, including reported amounts from his mother and great-grandmother. But inheritance and current income are 2 different things, and the key issue now is how much liquid money remains after years of major expenses. Security is another huge cost. Harry has repeatedly argued that serious protection is necessary for him and his family, particularly when travelling. That security dispute is central to his separate legal battle over government protection. But here's the uncomfortable part. Legal costs are now arriving at the same time as those security expenses. The more money required for protection and other commitments, the less flexibility there may be to handle a potentially massive court bill. For years, the bigger financial strategy appeared to depend on continued income from deals, media projects, and other ventures. Now the court dates are forcing those financial questions into the open, and the timing couldn't be more difficult.
Do you think Meghan and the kids will come in September?
No.
Why not?
Because all the chatter about it has subsided. Because you were hearing lots before of like, they might come, and now you're just not hearing any of it. You're just hearing, no, it's just going to be Harry.
Look at what those 2 numbers actually show, because this detail has been widely misunderstood. Total traffic reportedly rose from 246,000 to 268,000. On paper, that's growth. But American traffic reportedly fell from 108,000 to 89,000, 19,000 fewer visitors in 1 month. That's a major detail, because America is where Meghan built her brand and where the products are primarily marketed. So while the overall number went up, the American audience went down. The headline may look positive, but the underlying numbers tell a more complicated story. Then there's the candle issue. In October 2016, Meghan reportedly described a $100 candle as obnoxious during an appearance. Today, a candle set reportedly sells for around $262, including matches. That's a striking contrast, although changing views on luxury products aren't unusual. Another claim making the rounds is that the Prince and Princess of Wales have overtaken Archewell in America. If accurate, that's significant because America was the market Harry and Meghan chose after leaving royal duties. But comparisons between public profiles and charitable brands can depend heavily on how they're measured. The bigger financial picture is also getting attention. Questions remain about speaking income, brand performance, charitable activity, inherited wealth, and substantial annual expenses. And the court ruling is expected during the week of August 17. If that were the whole story, it would already be a major financial moment. But it isn't the whole story, because there's another legal case.
But that doesn't mean that Harry is ever going to be allowed back in as a working royal. I don't think this will ever happen. At the very most, he would be allowed back in a limited way for private family events in the way that Andrew is.
A defamation claim involving Prince Harry and Mark Dyer was filed in the High Court in March. It's listed as Centerval versus the Duke of Sussex and another. The case concerns allegations involving a charity connected to Harry's late mother, and the woman bringing the claim has reportedly confirmed that the charity itself is not paying her legal costs. The bigger question is simple. Who is funding the case? That's the view of one King's Counsel, a lawyer with years of experience warning clients that defamation cases can become extremely expensive and risky. His argument is straightforward. Bringing a libel case in London can require deep pockets or financial backing. If the charity isn't paying, the obvious question is who is covering the legal costs. But that's still speculation, and it should be treated that way. The lawyer himself has reportedly presented it as a possibility, not an established fact. What matters is what could happen if outside funding does exist. A potential funder may not be focused on damages at all. In a defamation case, one of the most important stages is disclosure, the process through which relevant documents and communications can become part of the proceedings. That's where the case could become much more significant. Depending on the court's orders, that process could involve messages and other records connected to the dispute. For Prince Harry and Meghan Markle, that's particularly sensitive because privacy has been central to many of their public and legal arguments. Disclosure isn't about personal principles, it's a legal procedure, and the court decides what information must be produced based on the rules of the case. There's another important piece of context. Last August, the Charity Commission reportedly completed an inquiry into allegations connected to the dispute and said it found no evidence of bullying. That does not determine the outcome of a separate legal claim, but it is certainly relevant background. The charity is reportedly not funding the case, while the identity of any outside funder has not been publicly established. So the question remains open: who is actually paying for the litigation? And then there's the timing. Harry is facing a potential £9.9 million interim payment in one case, while another legal dispute could create further costs.
Interesting.
Let's remember, Harry has done far worse damage than Andrew did. And Andrew was never disloyal to the family. Harry has been disloyal.
Two major legal battles at once could put serious pressure on anyone's finances. That brings the bigger issue into focus. If substantial court costs arrive while other expenses continue, where does the money come from? For Harry, his public profile remains one of his most valuable financial assets, and that makes the ongoing relationship with the royal family and its wider public image a particularly important part of the story. The chatter has stopped, and when the public discussion suddenly goes quiet, people naturally start asking why. In July, Harry reportedly arrived alone. His wife and children did not attend. The security dispute was given as the reason, while the palace publicly clarified that it had not even been told whether the king's invitation had been accepted. That paints a very unusual picture of the relationship. It's less about open estrangement and more about administration. A royal household having to clarify that it doesn't know whether its own invitation was accepted is a striking detail. The reported running order was the husband first, then the children, and finally the Duchess of Sussex. That's based on a single commentator's account, so it should be treated as reporting rather than established fact. But there were no widely circulated photographs, interviews, or public moments from the meeting. And that matters because a highly visible royal meeting could have had real value for Harry and Meghan's public image. Instead, there was little they could publicly use from it. Then comes the Andrew comparison, and the wording matters. The argument isn't necessarily that Harry is comparable to Andrew in conduct. It's that the most favourable version of Harry's future royal relationship could resemble the arrangement currently applied to the Duke of York: private appearances, no official role, and no return to working royal duties. For Harry, even a limited relationship with the king could still have major value. A royal meeting can attract attention, influence public perception, and potentially affect commercial interest. In that sense, reconciliation isn't just emotional, it could also have financial value. The Prince and Princess of Wales have also reportedly maintained a position that they would not arrange private meetings outside a potential official public engagement. If that reporting is accurate, it's a very different approach from an informal family reunion. The king may be willing to keep the door open, while the heir appears to be taking a more structured approach. But here's the important part. The judge has not ruled yet, and several of these claims remain reported rather than proven. He is expected to rule during the week of August 17. Nothing has been decided yet on indemnity costs, and the claimant's barrister may be completely right that the demand is excessive. Publisher cost estimates can be reduced significantly when courts examine them. The funding question in the separate defamation case also remains unanswered. No funder has been publicly identified, and the suggestion of newspaper involvement remains only a theory that could prove wrong. Prince Harry also strongly rejects the defamation claim. But strip all of that away, and one document remains. His own legal team told the High Court in writing that if indemnity costs are ordered, the £16.2 million insurance cover could fall short, potentially by many millions. That wasn't a leaked rumour or a media claim. It was filed with the court. You don't normally warn a judge that your insurance may not stretch unless you've already considered the potential exposure, and that's where the numbers become serious. 97 claims dismissed. A 436-page judgment, costs exceeding £34 million, described by the judge as unprecedented. More than £9.9 million sought up front. A ruling expected during the week of August 17. Costs applying across the 7 claimants, leaving little room to simply step away from the wider liability. Then there's a statement Harry signed while 5 co-claimants did not, which is now being cited in the argument for an indemnity costs order. And finally, the £16.2 million insurance cover that his own barrister has warned may not be enough. Those are the facts the court now has to weigh, and the final financial outcome still depends on what the judge decides. £16.2 million, that was the number. But it was never guaranteed to save him. It was the amount that could show just how large the potential shortfall might become. £30 million from his mother, reportedly gone. £10 million from his great-grandmother, reportedly gone. Around $6 million a year reportedly going out on Montecito operating costs. A brand facing questions over its American audience, while the overall traffic numbers can make the picture look stronger. And a charitable foundation whose profile is now being compared with that of his brother's organization in America. And behind all of that sits a second legal case, with questions still surrounding its funding. If outside funding exists, its real significance may not be the damages at all, but what the legal process could require the parties to disclose. That's especially sensitive for someone whose public battles have often centered on privacy. For years, Harry has taken legal action arguing that private information should remain protected. Now, the legal process itself could put more private material under scrutiny. That's the twist that makes this story so complicated. Now, I want to hear from you, and be specific, because I read these comments. When Justice Nicklin rules during the week of August 17, do you think he orders costs on the standard basis, Or does he go with indemnity and push beyond the £16.2 million cover? And if you want more breakdowns like this, hit like, subscribe, and turn on notifications so you don't miss the next update. I'll be watching the comments to see which side you think gets it right.